Hi, I'm Greg Dell here with attorney Cesar Gavidia, and we're going to talk about the keys to winning a Unum disability benefit lawsuit. Cesar, you've handled thousands of Unum disability lawsuits and reviewed thousands of denials. Unum's the world's largest disability company, so you're intimately aware of every aspect of them, how they do things, why they do things, when they're going to do things. Nothing surprises you, obviously, from when you get anything from them that's a denial. But clients call you and they go, I've been denied by Unum. And there's certain things that are immediately coming to your mind about what do I need to know as the lawyer to win this Unum lawsuit. So what are those first things that you think about when someone's calling you and you're evaluating a claim to determine whether or not you could win their Unum disability denial lawsuit?
The very first thing we ask them for in order to really dive into that question and that analysis is their policy and their denial letter. And the reason those two things in particular are important is because one, the policy is going to describe all the terms, conditions, all the rules, the definition of total disability that make you eligible for these benefits. How long you're paid, how much you're paid, exclusions, limitations, everything. It's the Bible in terms of your disability claim because everything flows through that policy. It's the way that the claim is evaluated from the insurance company side, from Unum side. The court's going to rely on all of those terms and conditions if it gets to the point of litigation and a lawsuit and determining if you're eligible for those benefits. So it's critical to have that policy. The denial letter is important because it's going to describe and provide you with all of the reasons that they're denying you. They should be explaining to you in the denial letter, at least that's what ERISA requires, is for them to, in detail, explain to you the reasons you're being denied, what you could provide to make your claim better,
Right.
Or what's lacking. Those things are supposed to discuss in that denial letter. And if you've come to us now and you've gone through the appeal process, either on your own or maybe through with the help of someone else, we're looking to see, because oftentimes in that final denial letter, they're addressing things you've now submitted as part of your appeal. So it's really important for us to know, well, what did you submit as part of the appeal? Is that appeal going to really be up to snuff to be able to say, hey, if we have to now go into a lawsuit, what are our chances of success in winning?
So because you're about to go down a road that I want
Right.
people to understand, because when we do these videos, we always take the assumption they don't know anything about this. And they shouldn't know anything about this ERISA world because they've hopefully never been disabled before. And number two, they've hopefully never been denied before if they've been disabled and this is the first time they're encountering this. But you start to talk about wanting to see their appeal. And the reason you want to see their appeal is because once someone comes to us for a lawsuit, we are married to the evidence that's out there already. And that evidence is already in the form of what's called an administrative record or a claim file. And so you talked about needing the denial letter and needing the policy, but that just scratches the surface. Mm-hmm. The next step is we need to really see, if we think there's an opportunity to move forward, we need to see this claim file. And this claim file, Cesar, as you know, is often hundreds, if not thousands of pages. And in that claim file is every single thing that Unum did to evaluate this claim. And when you dig into that and you're looking for the key to how am I going to win this lawsuit, why is that claim file so important to you?
Well, like you said, it contains every piece of information that Unum used to make a decision to deny your claim. Okay, so that means if they relied on any physicians to do a review and provide reports, those should be in there. Those are often provided to you as part of that appeal. And it's important actually, when did they give those reports to you? Did they give you an opportunity to respond to those reports? That's a real critical part of your case. If you had a real true opportunity to have a full and fair review by responding to the doctors that are experts that they used to decide your case. If you didn't, then that's going to be a critical point of the litigation.
So from a global standpoint, looking out at this, you're looking for multiple faults in the review that Unum did, weaknesses in the review that they did. But why is it so important for you to find those things?
Well, we're going to start to get into now the question of the law that's applied jurisdictionally, across the country in these ERISA cases. And very often a court's hands are tied into this abuse of discretion standard of review. In other words, the insurance company's decision is given the benefit of the doubt at the federal court trial level. Yeah, when I explain that to people, they're like, well, how is that fair? Well, it's not, but that's what we have. That's what Congress basically allowed for the insurance companies to do. That's what the courts allow them to do, apply this discretionary standard of review. And thankfully, more and more now, states are finding, hey, this is actually inconsistent with our insurance laws. Insurance companies shouldn't have this, this afforded to them, this abuse of discretion standard review. But unfortunately, there's still a lot of jurisdictions. So we're basically looking for these kind of real problems and flaws in their decision-making process, because that's going to help us overcome this standard of review. Or where in places where maybe that standard of review isn't applied, that may give us a really good opportunity or chance to win your case. Okay?
When you talk about this benefit of the doubt is going to be given to the insurance company, another way that I explain it to potential claimants and for people to understand is that if there is a discretionary clause, which we talk about it and it's a very technical term, but it's basically a line in your policy that says Unum Insurance Company has the discretion to interpret the terms of the policy and also make a decision on paying the policies. But more importantly, it says they have the opportunity to interpret the terms of the plan. And if they have that, the case law in about 35 to 38 different states says that, judge, if you're presented with a case where there's a discretionary clause, you have to first determine, number one, did the insurance company make the wrong decision, yes or no? If you think they made the right decision, just looking at it, then it's over. You affirm the decision, uphold the decision of denying benefits. But judge, if you find that they were wrong, then you have to determine if they acted reasonably. And you have to defer to them in terms of if they acted reasonably. And that's the benefit of the doubt that you're talking about. I mean, the law says, did the insurance company act reasonably? And the question now becomes, Cesar, is that reasonable standard? How do you determine what's reasonable when you're trying to figure out how a claimant can win their Unum disability lawsuit?
Right. And what's important here is it's not so much what I determine what's reasonable. It's what that judge is going to determine what's reasonable. And you got to be, and people need to understand, it's not like TV. You don't get a jury trial. You don't get a panel of your peers deciding if the insurance company, as you said, abused their discretion, the insurance company abused their discretion, or first, made the wrong decision, whether you're disabled, and two, whether they arrived at that decision unreasonably. You don't get that. So you get this judge who's obviously coming in with all of his own life experience and his knowledge and his own expertise in terms of ERISA, because it's a federal law. So, you have to assume this judge is familiar with these ERISA cases. He's got law clerks that work for him. They're doing all the legal research. He's reviewing all the briefs that are submitted from the defense and from your lawyers. So it's really what that judge is going to determine to be reasonable. And we've had cases where we went in fully confident there's just no way that this judge isn't going to find that the insurance company acted unreasonably. But people have to understand there's no guarantee of anything.
But can the judge just sit there and be like, look, I'm 65 years old, I've been doing this for 20 years, and this is what I think is reasonable? How does it help someone to understand, how does the judge's decision come out, and what does the judge need in order to support their decision, other than just sitting there going, I think this is reasonable?
Well, this goes back to something that you were saying in terms of this being the Wild Wild West, right, in terms of ERISA. So they're looking at the body of case law out there that's interpreting what is reasonable and what is unreasonable or an abuse of discretion. Okay, and the area of law is really so vast and expansive.
Hold on 1 second. I say that all the time, so people are getting confused. When I say the body of case law out there is the wild, wild west, what does that mean? Because people are watching this, they don't know what we're being too specific for them. What does that mean, this case law, and how we think it's the wild, wild west?
Well, case law is basically the authoritative body of law or persuasive body of law that's going to be governing in these ERISA cases. Okay, so past cases that have come up through the courts and cases that have been decided by the federal courts. Some have been favorable for your case and some haven't been.
And how many are out there in the world of
Thousands.
ERISA?
hundreds, thousands of cases. Jurisdictionally, because we're talking about across the country, right? So in that, in terms of what depends, what's applied in your case is depending on where you reside, where your lawsuit's brought, okay? And your lawyers, and we're not usually just pulling from our body of case law, our authoritative body of case law, because sometimes you could look at a case in in the jurisdiction that that we're bound to, but maybe in a neighboring jurisdiction, there's a persuasive case that we could bring in, and we could argue that persuasive case, very well to the court, to where they say, hey, you know what? That's what I'm going to rule based on that persuasive body of law, or that authoritative body of law in that other jurisdiction. I'm going to apply it here because that's really what's fair and equitable in this action.
So what I like everyone to think about, I always like to dumb this down. It's like baking a cake. There's 20 different ways to bake a cake, 100 different ways to bake a cake, right, with different ingredients or whatever. We gather everything. We start about these keys to winning. We need the denial letter, we need the policy, we need the claim file. Then we look at it and we go through it. And then we're racking our brains because you and I have reviewed thousands of disability federal lawsuit decisions that have been out there. And now we need to say, based upon these facts, can we find cases out there where, if it's a case against Unum, which we're talking about, and even if it's not Unum, it doesn't really matter specific to Unum. If it is Unum, it's wonderful, but it doesn't have to be Unum. But based upon a similar fact pattern, a similar disability, similar policy language, similar occupation, similar, yes, you paid the person, then you didn't pay them, all different factors. Can we find these other cases and relate them to this case to say to the judge, you can't just look at this and just say reasonable. You have to follow the law of the land, the law of this jurisdiction, and apply this law. Problem, Cesar, which is a good and a bad for claimants, I tend to say more good, is the case law is all over the place. And I'd ask you why it is, but there's a simple answer. That's just the way our country is. That's why we have the United States Supreme Court, which almost never, ever hears an ERISA disability case. They have on very few occasions, and it's not really a fact-specific issue. It's a global, the discretionary review case, something like that. It's a legal argument. It's not a factual argument. So for every one case that could be a positive to support your case, there may be 3 that are against you. Or for every 4 that are for you, there could be 1 that's against you, because it's 5 different judges that all looked at a similar fact pattern and 4 agreed and 1 didn't, or 2 and 2. And so winning these particular Unum lawsuits, these ERISA disability lawsuits, come down to not just the facts that could be very strong, but what's the case law that supports it, and how good are you as a lawyer in arguing that to the defense attorney and to the court, more importantly, to say, Judge, this is why you have to find this way. And that's why it's so important to get a lawyer who does this day in, day out, who's seen thousands and thousands of these cases. But when people call us and say, can I win? Look, I'll get everything for you. I will tell you the entire law of the land, your cases, I'll show it to you, and I almost guarantee you that most of the time you're going to look at it and go, when it's obvious, it's obvious. You'll know you're going to lose. And when you think you're going to win, it's still super hard. And what does win mean? Let's get into that now about what is a win, what are the outcomes that can come for a person.
I think, classically people think, well, I'm going to go to court, the judge is going to decide my case in my favor, I'm going to win. That's a win. I think people need to understand that a win could be a very favorable resolution in your favor in terms of a settlement, or winning on a particular issue that might have the case kicked back, or you paid a certain period of benefits. Because believe it or not, sometimes in these cases we file them, we get contacted by defense counsel or their national counsel, and they say, hey, I took a look at this case, and what I'd like to do, or recommend to my client, is that they pay your client and that they review now, going forward. And that's happened in a handful of cases for us. So I think you have to look at it. It could be basically the presentation of options, which may end up in a very, in a favorable resolution for you. Okay.
And all of these cases go to something that's called a mediation, required by law before a judge looks at it. And at a mediation, a claimant can be, and in all of our cases, is offered some kind of settlement. Not saying it's a good settlement offer, but it's an opportunity to say, look, I have a little certainty here. My case is worth $500,000. They're offering me $200,000 or $300,000 or whatever the number is. Do I now want to invest in this case?
Right.
Can I double my money? Can I triple my money? Can I quadruple my money?
Right.
Well, if your chances of winning are 10% and they've offered you it doesn't matter what they offered you if you have 10% chance of money. Now, if they offered you nothing, obviously you got nothing to lose. But if they offered you some kind of number that's going to make some kind of impact, and money in your pocket versus just saying, oh, it's just the morale of this, it's just the ethical thing that I have to do, it's principle. I don't like that when it's only based on principle because it's dollars. It's not for principle, I'm just going to throw $40,000, $50,000 into this when we're telling you you're going to lose. But at the same token, they could be offering you, not enough money, we think you're going to win, and many clients are just like, you know what, I want that level of certainty. The bottom line is, our job is to get the benefits paid. But getting the benefits paid may also mean, look, the company's willing, this is a risk situation, because that with these cases, if we win at trial, which we've won many, the only thing you win is the back benefits. So the case goes on for 2 years or whatever the period of time is, you win. Unum says, okay, fine, we're not appealing. Or if they do appeal, it goes on another year, year and a half. We get to the point where Unum goes, okay, we owe your benefits. Well, guess what? You only got paid your back benefits. Now Unum can say, we realize the mistakes we made. We're going to examine you again, and now we're going to cut you off, and now we're going to do it right.
Right.
Because we screwed it up the first time. We don't accept what the court did. We don't have to, and we have the right to constantly evaluate you. So people have to, they really get this opportunity to get a settlement and get away from this particular company if they want it. If they're going, look, I can't do anything. This is my only opportunity. I can't live on that money. There's no way in this world I can take that amount of money. I got to go. It's all I got. Then you got to go. And we'll do that. And we want to get as much money as possible for the clients. But they got to understand about winning this case is that it could be a settlement. It could go to verdict. It could be putting you back on claim. It's all what's good for you,
right,
as the client at the end of the day. So if you're someone out there with a Unum disability denial, feel free to contact Cesar or myself. No matter where you live in the country, we're available to assist you. And we look forward to providing you with a free consultation.